Look at the moves by the House of Representatives to strip the president of power to order assets for forfeiture. The House of Representatives took steps on Thursday to strip the president of the past to order the forfeiture of movable and immovable assets and to vest such powers in the court. The House passed for second reading a bill seeking to amend of the Currency Conversion Freezing Order Act Cap C43 laws of the Federation of Nigeria in 2004 to give discretionary powers to the judge of a high court to order forfeiture of assets of culpable persons. Leading a debate on the general principles of the bill, its sponsor and Deputy Speaker Ahmed Idris Wase said that the discretionary powers previously granted to the President by the Principal Act will be replaced by that of the High Court judge to align it with the spirit of the Constitution, as such powers could be abused by the President. Barrister Chime.
Yes, I think it's a right step in the right direction. If you look at Currency Conversion Freezing Orders Act, Section 9 particularly, that grants the President the powers, the discretionary powers to, forfeit, to order a forfeiture of assets, be it in monetary terms or movable or immovable property, for anybody undergoing investigation or trial. So I think that Section 9 of that Act is a contravention of Section 44 of the 1999 Constitution that guarantees right to own movable and or immovable property. And of course, if you are going to be derogate from that right, subsection 2 of that Section 44 provides for exceptions under which those rights could be derogated upon. So the law, the act that gave the president absolute power, discretionary powers to seize of anybody's property is unconstitutional. Again, it is a contravention of Section 36 of the Constitution that guarantees fair hearing. Because if the president wakes up every morning and targets his political enemies and decides to order a forfeiture of their assets, he becomes the complainant, he becomes the judge. At what point did he give the accused person the opportunity to defend himself? So it's a contravention, and the law is clear that if there is any conflict between the Constitution and any other law, that other law is null and void to the extent of its contrariness. So that Section 9 of Currency Conversion Freezing Order Act is a contravention of Section 1 sub 3 of the Constitution. Beyond the legislative amendment, I would have thought that somebody would have gone to court to challenge that Section 9, asking the Federal High Court to strike it down for being in violation of the extant legislation, the grand norm. So I think what the National Assembly is doing is proper. That section, as it is draconian. It was meant to operate during a military junta or dictatorship, where the president is the alpha and omega and there were no checks and balances. But under our present political and constitutional democracy, the Constitution guarantees some of these rights, and one of them is right to own movable or immovable properties, and that cannot be derogated upon. So it is not one of those exceptions provided under the Constitution.
All right, Barrister Jandi.
Well, first of all, it's important to commend the Federal House of Representatives for taking that move, which is one of their primary rules to make law. Yeah, indeed, we're operating a democracy, and things should be done in accordance with the law. And although that particular section has not been challenged in court, they have seen that it contravenes the provisions of the Constitution, which guarantees the natural right of fair hearing, where it is not fair for somebody to be the judge and the prosecutor at the same time, which in this case that's Section 9 of the Currency Conversion as freezing orders intends to. Now at the presentation during the second reading of the Deputy Speaker did mention the issue of the mechanism when you look at it, he mentioned that there's not enough mechanism provided for in that law, where fair hearing is given. Neither is there any, administrative or legal in that. So I think it's a good step in the right direction. The powers, the discretionary powers to order that forfeiture should be given to the courts, where an accused person can appear and properly defend themselves. Like my learned friend did say, the Constitution in Section 44 guarantees that right of a citizen to all movable and immovable properties. And where there is any instance where such a property is to be forfeited, an opportunity needs to be given. And so the discretionary powers of the president, the mechanism is not properly defined in the law. And I think the House of Representatives are doing the right thing by trying to amend that very section so that the courts can be given the opportunity, the judge of the High Court can be given the opportunity where anyone accused, can appear and then defend. If there is need for the order to be made, then in that instance it will, and then of course it will go to show that the natural principles of fair hearing have been complied with, unlike what we have here. We have instances of that, like the EFCC Act. It is the courts that ordered forfeiture, and you have so many other laws. But, this very currency conversion freezing orders, contravenes that, that provision. So I think it's a good step, and now that the bill will be remitted to the committee stage, I believe that they would speed up the process so that by the time it is passed, I believe the Senate will also adopt same so that the president can give it assent. So I think it's a work in progress, and at this stage, we have to commend, the National Assembly for bringing out this bill and working to ensure that fair hearing is given in this instance. Of course, at the end of the day, one can see that those who own properties are the politicians per se, but you can never tell what tomorrow holds. So it's important that we have laws that are operative in the current trends.
All right, the key word there being laws that are operative.
Yes,
or you want to add something? Okay.
To also demonstrate the absurdity in that law. Although I have not heard any instance where the president exercised such financial powers.
I was going to ask that.
It's already there in the paper, but because power has not been exercised, does not derogate from the powers of the president to do that. So the absurdity that are also inherent in that section 9 sub 1 is that it also criminalizes, or penalizes defaulters. If you are refusing forfeiting your property as directed by the president, you risk being going to prison and payment of, I think, 10,000 naira. But like I mentioned, perhaps the president or subsequent president we've had have never had any cause to exercise those rights or discretion as it is. But it is important that we bring in our laws in tandem with our grand norm, which is the Constitution, and being a violation of same, I think the proper steps should be taken to ensure that citizens' rights to ownership of properties, both movable and immovable, is not being violated.
Well, just to add, whether if the president has ever used that law, well, it's difficult to say because the president needs not, order the assets by himself. If you look at the law, the governor of the central bank, is empowered under the Currency Conversion Freezing Act, to carry out those orders, and usually it's given to the banks. Sometimes, you have instances where someone's account is frozen. Sometimes you try to wonder where it's coming from. So usually an investigation is carried out, and if the recommendation is made to the president, and if he agrees, nobody questions the mechanism he uses in this instance, because if it is not made out in the public where someone comes to defend himself, then it's a discretionary power that is not questionable. So I believe that law has been implemented in breach. But because the way it is carried out, perhaps maybe one has not really challenged.
No, it has been challenged. It has been challenged. You mentioned banks freezing customers' accounts. The law is clear. The Supreme Court has held in a plethora of cases that banks or financial institutions, even law enforcement agencies, does not have right to freeze the customer's account without the order of the court.
Without the order of the
but
court.
this still happens.
It's illegal. Of course, it's illegal. If you challenge it, you are going to be compensated. The banks don't have any right to freeze anybody's account without an order of court of competent jurisdiction.
Wow.
What happens is that in most cases, either the EFCC or the ICPC will file an ex parte motion to the magistrate court, any court that has jurisdiction, seeking for an order to freeze that account temporarily so that it doesn't jeopardize the investigation or the rest doesn't get altered or diminished. So it's to secure the property they are fighting for. So that is what the law says. It does not guarantee anybody, be it the EFCC or the bank. What bank does, I know that in practice, usually banks could bend backwards, but that doesn't make it the proper thing. What bank does is that, particularly when there are issues of mistaken transfers, you quickly rush to the bank. The worst case, what the bank would do is to place the PND on that account for a few days, asking you to now go to court and get an order for them to revert the money to you. So if bank would do this in this situation, they don't have any right to freeze anybody's account. And I think both the legislatures, the banks and the executives understood that section 9 of this currency conversion freezing order is unconstitutional. And the courts in Nigeria has also struck down that section. Though not expressly, but by necessary implications.
But with this review down, we are going to get something watertight, people can. What we talked about, from time to time, we've always talked about the fact that we need to review some of our laws. With what these members of the House of Reps are doing, it's an indication that we need to just go through our law books. Those laws that are inconsistent with the provisions of the Constitution, they need to go or be reviewed.
Yeah, very true. Just that is the sentiment of every right-thinking person, for us to have functional laws. But when you look at the legislative process, it's quite cumbersome. Sometimes it's really frustrating. Usually when it is an executive bill, accelerated hearing, and sometimes, the stages of lawmaking, sometimes are kind of like abridged, Now, this very law we're talking about now has just gone through the second reading. Now, it's a member's bill, so, of course, he must have gotten the support of his colleagues in the House.
Yeah.
So I believe that the committee that the bill is now referred to will also expedite action in bringing it back so that the third reading can be carried out. But I think for a private individual's bill, when you look at the procedure, it can be done, but it's usually very, very challenging and difficult. Oftentimes, it's quite frustrating, by the time you look at the approach and the procedure involved. So oftentimes people resort to challenging such laws through the law courts.
Okay.
And where that is done, it is expected that where the court holds that the law is inconsistent with the provisions of the Constitution, the legislative body is expected, through its powers to enact or to review. So I believe we should be having more of this. Because we have other laws that needs review too, to bring it in consonant with the modern day realities, so that we don't keep going back to obsolete laws that are actually operative here.
Or when things happen, we are looking for the right laws to back them up. You recall the issue of Kogi State, where we just had to resort to the Supreme Court for interpretation.
The truth is that law, I think that law was made as far back as 1972.
Wow.
Yes, it's one of the smallest legislations we have in Nigeria, about 11 sections. Like you mentioned, it was being directed to the central bank. But you've seen other legislation that deals with financial activities also gave, the banks the power not to, tamper with the properties of the customers without recourse to the due process of law. So like he did mention, law is dynamic and society is evolving. So must always and constantly be in tune with the changing times.